Your name, sir?
Lyman Wilson.
So what are we doing to this? He's pleading the no ops. They're dismissing the suspend on file 39018. True?
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
If you plead to that, the possible penalties are up to 100 fine, 90 days jail, costs are all those. Do you understand that?
Yes, I do.
Did you sign, read, and understand the advice of rights?
Yes, I
If
did.
you
Your Honor.
plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
To the charge, no valid operator's license on your person. How do you plead?
Guilty.
Were you operating a motor vehicle in Irene near Carter in Brownstown, July the 13th to 23 at 9:31 p.m.?
Yes, sir.
And did you have a valid license on your person?
No,
Are
sir.
you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it, suspends, dismissed. And then I've got all these failures to pay. Tell me he came with a lot of money today. Tell me he came with a lot of money today. Tell me he's got at least $500 or $700 today, because the owed the board a ton of money. He knows we're not a bank. You've explained that to him, right? Why you been playing with us, Mr. Wilson?
Your Honor, I just haven't been in a good financial state. I'm in a good financial state now, so.
So you got a lot of money with you today.
Well, I wouldn't say a lot of money
Well,
today,
that's a lot of money.
but I can,
What, you said you got, wait a minute, how much do you have?
Oh, I only have like $100 today, sir. But I can make another payment tomorrow when I get paid.
What have you been doing? Where do you work here?
I work at Hearns Industrial Services.
How much you make?
Now I'm making around 75,000 a year, sir.
How long you been working there making 75,000?
I just started this job, so I want to say this is my third week here. But before that, I was a material planner somewhere.
Where,
This place called Hollingsworth in Dearborn.
how much were you making there?
About 50,000, not a lot.
Are you married?
Yes, sir.
Kids?
Yes, sir.
How many?
2 kids.
Your wife work?
Yes, she does.
Where does she work?
She works at PSCU. It's a financial institute, a call center.
Public Service Credit Union?
Yeah, public service credit. Yes.
Smart, well-spoken guy, right? Don't you think?
I think so, Judge.
But why is he acting like a criminal by,
So, I think it's all financial, Your Honor. He understands that he could have been making payments, but I know kids can get to be expensive, bills, he's trying to take care of everything now. He also has other reports that he has to pay. So I would ask if the court would allow him to pay 100 today and make a substantial payment tomorrow.
Yeah, it was just a big financial role. I was trying to keep myself out of.
how old are you?
I'm 43.
You're getting a little old for this, aren't you?
Yeah, I am. That's why I'm trying to get this out the way and get this behind me finally. It's been too long.
On the no ops, if I let everybody finish.
Yes, Judge.
Have you finished?
Yes.
100 fines, 50 costs, 75 victims' rights, $50 justice assessment. I don't know if I'm 270 or 5 or 60 days. How old are your kids?
I have an 18-year-old in college and an 8-year-old son.
Where's your son going to college?
Oh, my daughter goes to college at UCLA.
UCLA? Good for her. What's she studying?
Psychology.
Wow. I would like to have gone to UCLA when I was, huh?
I didn't pay for her, sir. It's full ride.
For what?
She's very smart.
She got an academic scholarship?
Yes.
Well, I wouldn't have gotten an academic scholarship, John, to UCLA or anybody else or anywhere else.
Pretty good school. Yeah.
Not as good as Notre
like
Dame,
that.
but still, it's in the ballpark. $100 now. Can you pay the rest on that tomorrow?
I won't be able to pay the whole thing tomorrow, but I can make another payment next week, sir.
Judge, you mean the rest of the 270?
$275.
Oh,
So,
yeah.
yes,
So you can pay 170 more into 175 more tomorrow.
Yes, I can.
100 down today, the rest by July the 16th. Now, Heather, let's go through Mr. Wilson's files here before I get too agitated. And we'll figure out how much he owes on all of these. And then you're going to give me a reasonable time frame when you can pay these. Let's start with 901B. How much does he owe on that?
That one has a balance of 362. That includes the clearance.
When can you pay that?
I could pay everything by the end of August, sir.
On the 901B, you pay $300, including the clearance fee, by August the 3rd. Balance will be waived. You got that? You can do that? $300 by August the 3rd?
Yes, sir.
All right, let's go now on, Heather, to the one that, look at this. How much does he owe on 266B, Heather?
That one is 284.
Tell me when you can pay that.
End of August, sir.
Are you sure?
Yes, I'm sure.
You pay this in full by August the 31st, or are we off? No, are we off that day?
Let me take a look.
No,
No, we're here.
yeah, what am I thinking? Defendant to pay in full by August 31. How much is the balance on that?
That was 284.
Balance reduced to 250. On 266C, how much does he owe on that?
That one is 362, also including the clearance.
Pay $300, which will include the clearance fee. I want to be clear about that. Includes the clearance fee by August 31. Can you do that?
Yes, sir.
Balance waived on that. How much does he owe on 2OM786-266A?
266A is 621.
Defendant to pay $550 by September the 14th. Balance waived. You do that or not? Maybe you can't. Maybe you're committing to pay too much now.
Well, sir,
I'm asking you if you can do it, yes or no?
can I ask if you can move that, the first payment that was due on August 3rd, can you move that further down as well?
Jesus, why didn't you, well, you know, I'm gonna give you till September 28th to pay on this. I don't know which file he's referring to. You?
The 275 is.
The one that was August 3rd was the 901B.
You're pushing me, you know? You are pushing me. You don't want to push me too far. What do you want now? You want me to send
The 901B, he just needs more time than April 3rd.
make it April the 20th? Can you do that?
August the
I'm
20th?
sorry, August the 20th.
Yes, I can.
You don't have the money, you come talk to me now.
So,
Don't ignore me again. I'm telling you, if you do this again, I'm gonna send you to jail on all these and you're gonna lose a lot.
Judge, I've been to every court that you scheduled so far,
Good,
so
good,
I'm not missing anything else.
fantastic. Good luck to you.
Thanks, sir.
Thank you, Judge.
Seem like a nice guy. Grow up a little bit, will you?
Thank you.
Jean Louise Trozine, 205I-2886. See, now I just love these. Ms. Trozine, your name.
Jimmy Garcia.
Remind me, where have you been for the last 21 years? I want to go back 21 years in time. You know how young I'd be? I'd be almost as young as Mr. Carmen.
Almost.
So I was on crack for.
Okay, well, fair enough. At least you're honest. You're gonna plead to impeding traffic, right?
Yes,
Did you post a $200 bond
yes,
to impeding traffic charge, responsible and not responsible?
responsible.
How do you support yourself now?
On Social Security?
Tell you what. At least you were honest. I'll make it 150. We'll reimburse $50 for you. The bond. And
Judge, she
We're
does
gonna-
have a clearance fee also.
okay, so you got a clearance fee of $5 or $45. So you're gonna walk out, not today. You'll probably have to give it to you tomorrow. I don't know. We got a lot going. So you make sure you take care of your clearance fee. That'll be $45 plus the 150 and we'll reimburse you for the $5, okay?
Okay, when do I have the clearance fee?
You don't have to. We're gonna take it out of your bond right now.
Okay,
Is that fair?
yes.
Is that bond in her name? It is, right?
Yes,
Okay.
it is.
Go down and you can deal with them, okay? Thank you.
Thank you.
Where in the world is Troy Ross? Crystal Angelette Troy Ross. 26F 709053 FY.
Good morning, Your Honor. Michael A. Carmen, P7 on behalf of the defendant.
What are we doing on this one? Your name, ma'am?
Kristen Pearl.
She not show up for something?
Yes, Your Honor. I believe it's a VOP show cause arraignment. After June 25th, he no longer had the address that was listed. She had to change to a PO box, which I wrote down on the register. So she didn't get a notice, did not know that she had to be in court for the violation. I guess for the arraignment of the violation.
Didn't I tell you if you change your address, you have to notify us? I thought I said that. Didn't I say that?
Yes, sir.
Then why didn't you do it?
I didn't have insurance until I was able to get a PO box.
Where were you living?
So I'm going back and forth between a friend's house and a cousin's house on the Hampton Way.
So the charge here is failure to refrain from consuming marijuana, testing positive on June 17 of 26. If you plead guilty or if you are found guilty, that would be a first technical violation. And you could get 5 days jail. Do you understand?
Yes, sir.
Did she sign an advice of rights today or not?
I'm sure if we were proceeding to the violation.
I can at least arraign her. If you don't want to, or they don't, she doesn't, that's fine. You're presumed innocent. You have the right to a hearing. They have to prove you guilty by preponderance of the evidence. You have the right to bring in your own witnesses at the hearing. You use the subpoena powers of the court to bring in those witnesses. You can testify or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up your right to a contested hearing. Do you understand that? I'm gonna enter a not guilty plea. Is that what you want me to do?
Yes, Your Honor.
All right, so I'm gonna enter a not guilty plea for you. Young lady, you better, I hope you're gonna take this serious.
Yes, Your Honor. I did take another test a couple of days later and it was negative.
All right, here's what I'm gonna do. We'll just reschedule this. I'm entering a not guilty plea. I'll give you a $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, but I'm gonna tell you, this concerns me that you're being this aloof about it. You were charged with home invasion in the first degree, and you pled to aggravated assault, no contest, which is a 1 year. It's not like you pled to disturbing the peace or some similar crimes. So I don't know what to tell you. I hope you're gonna take this more serious. If you don't, you're not gonna like how it goes. We understand one another?
Yes, sir.
All right, give me a new date if you would, Heather.
Is there a date on that one, Judge?
You
I
got
believe
July
that-
20th. I'm good with that. July 20th at 9 o'clock. If you want a petition for a court-appointed lawyer going forward, we'll give you a petition. And I'll appoint you a lawyer if you're indigent, okay? All right, any questions? You're gonna take me serious, right? All right, good luck. Thank you.
Thank you, Your Honor.
Do you have all the,
Who's in the band?
he's waiting for Mr. Sonic. We're missing two, Foster and Siller.
He's in the first line.
Siller,
Cider?
Siler, we don't have, that's not synced.
Siler was adjourned.
Day. Oh, boy. I could be golfing Mosley today. Fawcett, Dariante Martel, Jawan Fawcett, 24B 14604 through A and B. Your name? You're charged with driving on a suspended. You also have a speeding violation that you paid money on, a bond posted on June 15th. Today is the date scheduled for arraignment and pretrial. Would you like an attorney? You have the right to one. If you want one, I'll give you one. I'll go ahead and arraign you then. It is alleged that you did operate a motor vehicle with a suspended license on June 23 of 24. They think you were operating that motor vehicle in Brownstown Township on Telegraph near Cedar Ridge at 11:44 p.m. They think you had a suspended license. That is a misdemeanor, is punishable by up to 500 fines, 93 days jail, costs of all those are 2 points. Do you understand that? Did you sign, read, and understand an advice and rights form here today?
Yes, sir.
If you plead guilty at any time, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
All right, you still wish to waive your right to a lawyer? You want a lawyer now?
Yeah.
Bonds continued $500 of entering a not guilty plea. I will send you to a lawyer who will go negotiate this with the prosecutor. You can go out in the hall. You cannot leave the state without consent of the court. You cannot violate any law. You must appear in court as directed. You understand all of that? All right, you're all set. Go out in the hall. We'll see you back in a minute. Phillips, Shannon, Sherelle, Phillips, 26B 1509058 and B. All right. Good morning, Ms. Phillips. Your name? Your name? All right, so you want a motion hearing date, right?
Yeah, I filed a motion for dismissal.
Yeah, I saw that. We'll give you a date. July 29th, is that good?
July 29th.
Yes.
I'm asking my judicial clerk
We could do that, Judge. We could do 9:30.
at 9:30. July 29th at 9:30. Did you send your motion to the prosecutor?
I did via email and I faxed it to the clerk.
Call in,
Well, do you,
call in the prosecutor, will you please, John? I'll tell you what, I got it. That's Ms. Foley Carter. John. Nobody's in there? Heather, just make sure she knows I need a response in 7 or 8 days. I need it a week, 5 days before at least, okay?
Okay, she may be in Judge Heston's courtroom.
Thank you.
you have a good day.
You too. Go down the hall. We'll give you your notice.
All right, thank you.
Daryl Keith Robinson, 26I-76095A, B, and C. So we're still setting it for formal hearing, right? Your name?
Larry Robinson.
Your name?
Morning, Your Honor, Matthew Wayne on behalf of Personal Township.
So did you guys try to resolve this or not really?
We did, Your Honor. I just wanted to also set some light familiar. So I spoke with Mr. Robinson. I asked him anything that he wanted me to know, he didn't. And I asked him if wanted to discuss this for a judge, indicating that he did. Your Honor, sent him back out. Township extended an offer to him. Mr. Robinson rejected it, as he was well within his right to do. And here we go.
Well, okay, I don't need to know what your offer was. We're just gonna go to a formal hearing on August the 26th then. He isn't.
I can move I looked at my flight, so I'm able to move my flight to Friday. If you do want to do 2 weeks.
Yeah, let's do it in 2 weeks, July 29th. How's that? So you'll have it at 8:30 still, Heather?
Yes, that's good, Judge.
At 8:30, okay? Thank you very much. Have a good day. Sir, go down the hall. We'll give you your paper notice, okay? Thank you. Mario, Salvatore Gabriel DiMatteo, 26B 839-108 B and C. Good morning, Mr. Zellman.
Morning, Judge, and Your Honor, it was Zelmack for the defendant. I apologize, that phone infarction was my fault, calling my client and tell her that I was in the parking lot.
You should have her phone muted,
Well,
or he should. I mean, I got phones going off in here all the time. I'm getting tired of it. They tell us we have to have phones, have to let people have phones in here, but they don't have to deal with us. You know what I'm saying? I mean, lawyers aren't going into the Supreme Court with their phones unmuted or muted rather. Unmuted, I should say, but anyway,
well, Judge, can I give you a quick story before we get into this dilemma here?
sure.
The other day, I was in front of Judge Salomon, and my phone is always on mute, and just before I walked in, I was criticizing all the lawyers for sitting there with a cell phone glued to their ear. My cell phone's buried in my pocket, and the judge's court clerk, Miss Albright, texts me to ask me why I'm there that day, because I had nothing up, and it goes off in my pocket. And of course, I couldn't get it out of my pocket in time, and it was coming out in French. Thank God Judge Salome spoke French, he understood what happened, but. So I made that mistake after I yelled at a bunch of lawyers for my cell phone, so today I got someone else in trouble, it was just the start of the meeting.
It's all right.
That's
It's okay.
sorry, Judge.
We're past it.
But he's such a nice, I mean.
I know, I just
work
have
for
it.
A lot of lawyers.
I know, I just have it happen so much, but at any rate, let's move on here. I'm gonna dismiss the civil infractions. He's gonna plead the animal vicious act, right?
Yes, Your Honor, we agree to the restitution.
And your name, sir?
Salvatore Gabriel Di Matteo.
Is that what you want to do?
Yes, Your
If
Honor.
you plead guilty here, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your
And
Honor.
did you sign, read, and understand the advice of rights?
You signed that form I gave you that said advice of right, right?
Yes, sir.
Do you understand that?
Yes, sir.
Thank you.
If you plead guilty, you're giving up all those rights. Do you understand that?
Yes, sir.
All right, and I want you to understand that if you plead guilty to this, the prosecutor is offering this to be taken under a statute, and if you comply with everything that I order, the case will be dismissed. You understand that?
Yes, sir.
All right. Did you sign, read, and you understand all your rights, right?
Yes,
Do you
sir.
have any questions before I ask you how you plead?
No, Your Honor.
The charge of animal vicious act, dog violation, how do you plead?
No contest. I think she checked no contest, and we'll take either one. What did she check on the box there?
It's got no contest. I didn't see it.
No, that's all right. I mean, Judge, because it's not going to be reported as murder, and they've agreed to the civil restitution, you'll change that to guilty. Is that correct? You understand under the ordinance by the dog running and attacking a dog that was deemed to be a vicious animal and pleading guilty to that. Is that correct?
Yes.
All right.
Yes, Your Honor.
All right. You know what's going on here? We're talking.
I do it. You kind of got me confused because I thought it was no contest, Your Honor.
Well, I didn't see it, and I did not see that. I'll be happy to go no contest, kind of start it over if you want.
Oh, we don't have to, you don't care, do you? Doesn't matter, it's gonna come off in 3 months.
Your Honor, it's to your discretion. If it matters, then I want
Well, then I'm gonna take no contest, if that's what everybody agrees to. You understand a no contest plea has the same effect as a guilty plea.
I do.
You understand you plead no contest, that I'm going to take that as a guilty plea. And Mr. Zelnick, will you stipulate that I can use the police report to establish a factual basis?
Absolutely, Your Honor.
Maybe mark that people's one. Sir, you understand by pleading no contest, you're giving up all the rights, possible penalties, and that the case will be taken under 771.1. If you're compliant, the case will be dismissed on motion of the prosecutor at the end of the specified term, which they've got here is 6 months. Do you understand that?
Yes, yes, and you understand also that the prosecutor indicated you'd be eligible after 3 months, if you comply with them.
So do you understand everything I've said?
Yes, sir.
All right. You have any questions?
No, Your Honor.
All right. To the charge of animal violations, vicious act, how do you plead?
No contest.
And counsel, you stipulate I can use the report to
Certainly,
establish a
Your Honor.
factual basis. All right, I've had that marked people's one. Was this dog okay?
The other dog is okay. There was no punctured skin. They took it to the emergency vet service somewhere in Saline because it just had surgery on a different part of the body. And there was an abrasion not caused by the bite, but there were no puncture wounds. from
I
this
still
dog.
really should let the victim appear here unless the victim's here. So I'll accept you're not on probation or parole, are you?
No, sir.
Anybody force you to plead no contest?
No, sir.
Okay, so I'm accepting that plea, dismissing the dog at large and no dog license. I mean, I guess I could call her in and see if the victim has indicated she doesn't want to appear.
Well, they've made a request for restitution and filed.
I know. John, call over Miss Foley Carter again, 249. And if,
They're neighbors, Judge. I don't know.
yeah, I understand.
The other thing you are is.
Miss Foley Carter, your name? Do we know if the victim, owner of the other dog, wants to or doesn't want to appear on this?
They might be very strong feelings, John.
Yeah, I'm gonna have to set it for a sentence date. I don't need a pre-sentence report. I will set it for a sentence date. We're gonna notify the victim You want to do the 29th? Are you good that day, Mr. Zelnick?
That work for you? That'll work for me, July 29th.
We'll make it at 8:30, Heather. We have to make sure the victim is notified. Do you mind doing that?
Judge, you make an inquiry now because this is the first time the dog has ever gotten out of the yard. There was a latch problem at the fence in the pool. It's never bitten anyone before, with no previous notice, and it's a rescue dog that they've raised. You consider removing the muzzle for the dog.
Oh, I'm not gonna do any of that till the 29th. I mean,
Can we get in sooner?
no, I gotta notify him.
Because there's no vicious propensity, and I explained to my client that as opposed to the common law rule, if you're entitled to one bite, the ordinance is malum per se, that one bite indicates, or one attack indicates a vicious animal.
There's some animosity here, maybe, isn't there?
Well, it's a neighborhood issue that started after the bite.
Yeah, I get it, but I'm not lifting that off. I just, yeah, I want to hear from the victim first, and that's the next day I can do it. I'm sorry. July 29th, 8:30. What kind of a dog is this again?
She is a German Shepherd dog.
I mean, how big is the dog?
For her size, and she should be 65 pounds. She's about 18 pounds overweight.
So she's 85 to 90.
No, she is 78 pounds right now. She's on her way back down.
Do you have a fenced-in yard?
Yes, sir.
There was a latch problem on the pool gate, which you repaired, and that's what they
Yes,
got.
sir.
Listen, I'm not changing my mind.
No, I don't.
Honestly, July 29th, that's in 2 weeks. Victim could show up.
You mean that day? You got a problem?
I'm good with the date.
Judge, one thing I wanted to ask was, because there's always neighbor issues, I don't like mediating, getting in the middle of finger pointing. Will there be some, I know the court's gonna enforce the court, but any neighbors shouting at each other?
It's not gonna
Because-
happen. You should know me better than that.
No, it's not you, Your Honor, it's the,
I'm not gonna let that happen. And you're gonna talk to him if you sense that that's a problem, right, Ms. Foley Carter? I mean,
no,
this is
thank you, Judge.
this is.
Because I understand that the victim, I mean, the defendant here, they're seeking a personal protection.
Yeah.
You ask for,
I'm trying to.
well, no, they can come to court on good, you know, so they, just, I will ask you, you should know better, you got law in your family. Judge, they're seeking a PPO against the victim and the victim's family, so.
Jeez, okay.
Judge, I know it all starts, I was a mailman and I don't like dogs, so I know how it is.
July 29th. We'll see you
Thank you.
guys soon. Thank you. Thank you.
They can ask me.
And by the way, there is a victim's rights statement in here in the other packet that I didn't see.
Well, let's hold on, what day are Agent Nita still?
No, I don't need you. You can review it before then, okay? Before the sentence. All right.
Yeah.
Thank you, Your Honor.
Have a good day. What else do you have? You have anything else down there?
Yeah, nothing. I think they're waiting on somebody from the.
Are we waiting on somebody from the county?
Somebody's in front today.
Heather?
No, they.
Not that I know of.
You said Bain, right? And he's locked up somewhere?
Yeah.
Where's Bain at? Is it BAIN?
You scheduled that one, right?
Prosecutor is,
What, was that Brownstown?
yeah,
Church.
disturbing the public intoxication.
He's in county, is that what? Let me,
This is what,
Wayne
I'm gonna
County
look
man?
right now. Wait,
Are you
I'm
sure?
looking, I'm doing a search right
hang on, I'm
now.
not talking.
Yes.
Yeah, it does
Even-
say that
even
he's
if
in
I'm
county. Let me
Bain,
call
he
my,
does say somewhere.
the deputy that I have a number for over there and
See if,
see what's
see
going
on
on.
this file, what kind of bond I set. He's not in custody on that, is he?
Okay.
Let
said-
me look him up.
Galen said it shows that he's in custody, he's got no bond posted. All right, well, they're trying to figure that out, so. Okay, thanks.
No,
Yeah.
He's got a 10% bond on our case.
So he didn't show up for a long time. All right, man, we'll figure it out. You stick seated,
All right.
okay?
I'm gonna call county right now, Judge.
Thank you. You gotta take care of the property, sir, okay?
Yeah, 100%.
So I'm gonna set it for a formal hearing in a couple of weeks, but you gotta take care of that, all right?
All right,
Good enough. We don't need to talk about it anymore. Give me a date if you would, Heather,
for,
a formal hearing.
That will be,
Is that what you want? It said,
yeah, definitely, because I want to discuss it, but, anything in September is fine for me.
well, I'm not going to September. This is civil.
Yeah.
This is July. I'm doing it the end of July in a couple of weeks.
The first week of August,
Why can't you do it in July?
got visitation in the last week of July.
You knew about this June the 9th, right?
Huh?
Where are you going? When?
Going to the defendant,
When?
26.
When is Grosjean here again?
after the, well, we have July 29th, or then we have them. You're off on the 12th, and then we don't have them again until August 26th,
I don't want to go that long on this.
because we only have them every 2 weeks.
August 26th at 8:30, okay? August 26th at 8:30, but I'm not gonna adjourn it again, all right? So get it done, and then they can take care of it, they can dismiss it, otherwise,
Is it to take care of the property or to take care of discussing the issue? Because the property is already fine.
well, didn't he talk to you about it? It says vegetation over in
Yeah.
10 inches on the entire property, junk, trash, unused, abandoned objects, boats, ATVs, tires, utility trailers times 2.
Yeah, I got 2 utility trailers that had some stuff from my shop on it. That was it, and then my 4-wheelers are always there. My boat's there, which they told me I was allowed to have as long as it's being on the property.
Did you talk to him about this case?
No, he just asked me, was there anything that I wanted him to know, and I said, no.
Why don't you tell him about all that? I got everything taken care of.
So he didn't address me, was, he just said anything you wanted to know, I said, no.
He's,
Just waiting on a judge, I don't know who he is, that could be the lawyer for all of them.
all right, well, he is their lawyer. He's their lawyer.
They're defending them, I'm going to talk to you directly,
Well,
or
you-
somebody who's not biased.
Well, I get it, that we're gonna have a hearing on these charges when you come back.
So would I can go, I guess, negotiate with them first, or
If you want to, I'll be glad to send the files back.
that's fine, I can do that.
Why don't you take these back, John, and tell him what was going on? He wants a chance to talk to him more, and we'll go from there, okay? Thank you.
Thank you.
So explain your situation. All right? What do you have, Mr. Sakla? How you doing?
Good, Your Honor. How are you?
Good. What case do you have?
I've got Bilothio. I can't say it now.
Jasmine June Belitho. Jasmine
Belitho.
June Belitho. Come on
Yes.
up here, ma'am. 260-150-954 A and B. Counsel, your appearance,
Your Honor, Freddie Sackler on behalf of Miss Belitho.
your name, ma'am.
Jasmine Blythe.
Does she stand mute, wait formal reading?
Waive reading, ask the court to enter a plea of not guilty, and
$500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. We'll give her a couple weeks to go get her clearances taken care of. What date do you have for me, Heather?
That'll be July 29th at 9:15.
Good with you, Mr. Sakla?
I am looking right now. Yes, Judge, that's good.
July 29th at 9:15. Okay, ma'am? So go take care of those, come back. We'll give you a paper notice down the hall. Any questions? Good luck to you. Daniels, Michael Ray Everett Daniels, 26B1501099 A and B. Where's Mr. Daniels at?
He's coming in on Zoom. He's in Missouri. It's taking a minute for him to, here he is.
Your name?
Michael Ray Everett Daniels.
You have 2 charges here, driving an unregistered vehicle and defective equipment. You have the right to a lawyer. If you want one, I'll give you one. If not, I'll arraign you and send you to the prosecutor to discuss the case. It's up to you.
I believe my wife had been in contact with you, sir, about possibly getting me a public defender.
You didn't call me. I mean, I don't take calls, or I don't know what you mean by that. If you want a if you want a lawyer, I'll give you one now.
Please.
Yeah, no problem. So I'll go ahead and give you a lawyer. You're entitled to one by law. So John, set him up on Zoom with the defense attorney, if you would, please. Thank you. Just be patient there. Alexis LaFay Harris, 26I, 261-014.
Good morning, Judge and staff. John Graziani, Premium Beef. Alexis Harris. Judge.
Ma'am, your name?
Alexis.
Go ahead, counsel.
Judge, I'm going to be asking for an adjournment. This is a bit more complex than I originally thought. She was under the impression that she qualified for a diversionary program because of somebody.
In what?
No, Judge, I get it. She does not qualify for any kind of diversion.
Not unless you find them.
Judge, I get it, I understand it, and I'm asking for, this matter to be adjourned because I have several other matters that have to be taken care of, and,
No, I get it. I just want you to,
Judge, I'm aware that she does not qualify. I'm not saying that
I
it's a
know.
matter of any disrespect.
I mean, I don't know how she'd be
She
under
would-
that impression with somebody with 15 convictions.
No, no,
I mean,
she would
you'd
have-
have to be in some other far off land like the Wizard of Oz.
Understood, Judge, we certainly understand.
Adjourn the hearing. Give me a date, July 29th.
Yes, July 29th. We could do 8:30.
You gotta stay out of trouble.
Yes, sir.
I think it's kind of, you're trying.
Been trying.
I would like to know what would happen if you weren't trying.
Judge, she's really had a lot of struggles, mental health struggles, more than the average.
I got it. Well,
She is a gainfully employed human being, and she is.
well, that's good. I'll see you back here July 29th.
Judge,
Okay?
thank you so much.
Have a good day. Good luck. Go down and get your paperwork. Drew Aaron Gerald Jr., 26B150241A and B.
No, that's fine.
Good morning, Judge Bianca, TOP 8237A, on behalf of Mr. Jarrell, station voting.
Drew Aaron Gerald Jr.
He's got 6 counts. We have 1 conviction for operating while visibly impaired. We have another charge, a drug charge that was taken under 7411. That was for cocaine. And he has 6 charges. I arraigned him on the charges. He indicated he wanted probation violation charges, I should say. He said he wanted a lawyer. I've appointed you. How we doing here?
So, Your Honor, he would like to plead guilty to the allegation with an explanation for each.
I can't wait to hear it. You understand everything I've told you so far, right, sir?
Yeah.
You understand that you would now have the opportunity, I'm just saying, with 6 violations. You could have your probation revoked and you could be incarcerated on this for up to 93 days on the impaired, 7411 status revoked on the drug charge, and you could get 90 days on that. Do you understand that?
Yes, sir.
And knowing all that, you still wish to plead guilty.
Yes.
And you just sign, read, and understand an advice of rights form in this courthouse today.
Yes.
You understand? If you plead guilty, we're going to be giving up all of those rights. And we're not going to have a hearing or a trial of any kind. You understand that?
Yes, sir.
All right. Now, as to count 1, to the charge you failed to pay fines and costs as ordered on both files. I told you to pay 75 a week. Last payment made, it says on June 1 of 26. How do you plead to that?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes.
Count 2, that you failed to comply with probation in that you failed the chemical test on May 27 of 26, testing positive for amphetamine through on-site. How do you plead to that?
Guilty.
Did you in fact test positive for amphetamine?
Yes, sir.
You didn't have any prescription for anything, correct?
No.
All right. Count 3, that you failed to provide verification of attending AA 3 times a week until an outpatient treatment. How do you plead to that?
Guilty.
Did you fail to attend AA 3 times per week?
Yes, Your Honor.
Count 4, That you failed to provide verification of attending and completing outpatient, how do you plead? Outpatient treatment with aftercare, how do you plead?
Guilty.
That you failed to do that.
Yes.
Count five, that you failed to provide proof of completing your 8 hours of community service by June the 30th, how do you plead?
Guilty.
Failed to do that.
Yes, Your Honor.
Count six, that you failed to clear all warrants by July 1 of 26 is ordered, how do you plead?
Guilty.
Failed to do that.
Yes, Your Honor.
Anybody force you to plead guilty?
No.
All right, John, I'm going to need Madeline in here. I'll accept your plea of guilt to all those charges. I find they have been made voluntarily and understandingly and are accurate pleas, so the plea is accepted as follows. Count one, the failure to pay fines and costs is ordered. Count two, failure to test negative, in other words, positive for amphetamines, add a chemical test on May 27th. Count three, failure to attend AANA 3 times a week. Count four, failure to attend outpatient treatment. Count five, failure to attend community service. And count six, failure to clear all warrants by July 1. Your name?
Madeline Office Probation Department.
You got your work cut out for you, Ms. Patillo. What's going on?
So, Your Honor, as it relates to the outpatient, Mr. Jarrell had found work. He's been working at VidCon for about 3 weeks doing sheet metal for the local 80. The reason that he didn't do that is because he was looking for a place to do it virtually, which would go along with his work. He did find a place to go to, but they had a copay, and at the time, he couldn't afford that.
When did he acquire his employment?
It was 3 weeks ago.
Yeah.
Was he going to AA the whole time?
No.
I thought I said to go to AA when I sentenced you on May 7th, 3 times a week until an outpatient.
You did.
And now you're saying you got work 3 weeks ago, which would put us at the latter part of June. And that's why you didn't go to outpatient, because you didn't have the time now. But yet you didn't go to AA 3 times a week, right? Am I missing something? I just want to make sure I understand. Is that true? Yes, right?
To an extent, I mean.
To an extent. Well, to what extent?
When I had the time, I didn't have any money. I mean, I
It doesn't cost money to go to AA.
Well, no, it costs money to put gas in my car.
Did I tell you? Give me a break. Did I tell you to call the court and go on Zoom with me if you didn't have the money to pay?
Yes, Your Honor.
So
You
that,
had the money to use drugs. He's got a problem. Go ahead.
well, the positive, and I
Can't wait to hear
don't want
that.
to misspeak, it was the Adderall pill that he had gotten from somebody at work. So it wasn't, he didn't purchase.
I see. So somebody else passed along an analog, contrary to law, and he took it and he ingested it.
Yeah, it was stupid. I made a bad decision.
After the warrants, the same thing with the money, Judge, he didn't have the money, I know.
I can forgive the money. I don't forgive the fact that he didn't call, but I'm not even worried about the money. I'm worried about the fact that he's testing positive, isn't in treatment, didn't do his AA, didn't clear his warrants. He didn't do anything. Did he do anything?
No. So Ryan, I would say it is my understanding that this is an 18-month probation. He was just put on probation May 7th, 2026. I would ask if the court would refrain from revoking the probation or any jail time while he was given dates to complete everything. He knows that. It's only been about a month and a half. And it is a struggle when you don't have a job and when you get a job and you try to keep that job. So now he understands how serious this is. That Your Honor could revoke probation, but I would ask if the court would allow him to continue on probation now that he has work and money. He should be able to take care of something.
Can I see the screening report? I don't just order AANA nilly-willy. There was something in this report that told me I needed to do this. I obviously didn't do a very good job. You didn't think, you're not listening to me at all. You were using cocaine, getting behind the wheel. What do you think?
I mean, in terms of not having a job, I can understand. However, Mr. Durrell was driving to school daily. It was a pretty far drive from what I recall, because that's actually why we missed our first appointment, is he was driving on the freeway still. So it would be easy to stop at a meeting, on the way or on the way home. So I am very concerned because at this point, there have been no efforts made, nothing's been completed. And he hasn't communicated with me at all, and, issues or anything.
Just the school was actually for his work. I don't know if that makes any better, but again, Judge, he was just put on probation on May 7th. I would ask if the court would give him a little more time just to be compliant with at least some of this stuff.
If you'd done some of it, I could listen to that. You did nothing.
Did pay a decent amount of fines, I believe. I shouldn't be that far behind, I don't think. Maybe 2 or 3 payments.
And he also brought $500 to me.
Yeah, I do have money now to.
Good, you can apply that to your bond or to your fines and costs. I'm not gonna order it any extra costs. You are, however, I'm gonna keep you on probation, subject to all existing terms and conditions. You're to serve 6 days jail forthwith. You have 21 days to appeal, 14 days to apply to a lawyer for purposes of appeal. Hope this doesn't cost your job, but I didn't. You will. If you have completely ignored orders. You're on a short leash with me, sir. It could have been a lot worse. Have a seat in the jury box. Good luck. Usman Ali Syed, 26B 1508779A and B.
Good morning, Your Honor. Deanna Patillo, 82378 on behalf of Mr. Usman Syed, to say
Small stated.
All right. So does he stand mute, waive formal reading for purposes of arraignment?
yes.
And then he's going to plead guilty to allowing an unlicensed driver to drive. And he's going to plead guilty or responsible to distracted driving causing an accident. Is that true?
Yes.
And then they're going to dismiss the misdemeanor charge of violation of instructional permit and the 2-point civil infraction of improper lane use. Is that right?
Correct.
Is that what you want to do?
Yes, sir.
If you plead to distracted driving, that's 0 points. It won't go on your record. If you plead to allowing unlicensed driver to drive, that is not abstractable, meaning it won't be reported to the Secretary of State. You could be fined $500, assessed jail term 90 days, costs are all avoided. Do you understand?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
You plead guilty, you'll be giving up all those rights. And we are not going to have a trial of any kind. You understand that? To the chart. Allowing an unlicensed driver to drive, how do you plead?
Thank you.
Were you in control of a 2011 Toyota that was being operated in the township of Brownstown on Western Telegraph, May 30th, 26 at 11:14 in the morning?
Yes, sir.
You allow somebody to drive that was unlicensed, and was that you? Are you on probation or parole? Anybody force you to plead guilty?
No.
And again, how do you plead to the charge of distracted driving? Responsible or not responsible?
Big responsibility.
Plea is accepted to allowing an unlicensed driver to drive. The original charge of violation of instructional permit is dismissed. I'm accepting the plea to distracted, dismissing the improper lane use. Counsel, anything you'd like to say on his behalf?
He is very young. He understood that what he did was wrong. He does have a valid full license.
Good. Good. Anything?
No.
195 on the distracted driving. On the allowing unlicensed driver to drive, given that you've got a valid license. 100 fine, 70 costs, 75 victims' rights fee, $50 justice assessment, 295 or 60 days. So it's 295 plus the 195. Your total is 490. Okay? Can you pay all that today or do you need time? How much do you have today?
$60 actually.
You pay 60 on the distracted Tell me when you can pay the rest of that. That would be another 140, 135. Balanced by August the 3rd, okay? And then on the other charge, I'm gonna let you pay $60 per week, beginning August 10th. Can you do that? You sure? All right, so 60 per week, beginning June the 10th on that. We'll give you a printout down the hall. I do wish you well. Good luck to you. Thank you. People against Z Force Transportation Inc., 26B1509898. I'm sorry, 09898 and B. Good morning, Mr. Robinson. Your appearance?
Paul Robinson, P number 39327, appearing on behalf of Z Force Transportation.
All right, so you met with the prosecutor. There's going to be a plea to overweight agreed upon fines and costs of $5,000, correct?
That is correct.
To that charge on behalf of the company, how do you plead? Responsible or not responsible?
Responsible.
And you're authorized to enter that plea on behalf of the company, true?
That is true.
Please accept and overweight $5,000 on that charge. Paid by August 15th. The defective equipment pursuant to the stipulation is dismissed. You're all set. Have a great day. Thank you.
Thank you. Have a good day, Your Honor.
To
Take
Wilson. DeJuan Andre Wilson.
Sometimes the hardest thing for a judge isn't deciding whether someone broke the rules. It's deciding whether that person deserves one more chance. This courtroom hearing began with a defendant who openly admitted violating one of the court's most important orders, a strict no-contact order. The defendant acknowledged that he had called his former partner several times, even though the court had specifically ordered him not to contact her. When the judge asked why he ignored that order, the defendant struggled to explain himself. He admitted there was no good reason. He simply reached out, hoping to talk, hoping to apologize, and hoping to have one final conversation. But the judge reminded everyone in the courtroom that a court order isn't a suggestion. Once a no-contact order is issued, it must be followed, no matter how good someone's intentions may seem. The protected person then spoke directly to the court. She confirmed that the defendant had left 3 separate voicemails. According to her testimony, one message asked to have a normal conversation, another complained about her family looking at his social media, and another apologized while acknowledging she had moved on with someone else. She admitted there were no direct threats in the messages, but she also explained that she had repeatedly asked him to leave her alone. The probation officer confirmed that the phone records matched exactly what had been reported, and that every voicemail came from the defendant's phone number. Although the defense emphasized that there were no new crimes or acts of violence connected to the calls, the judge made it clear that repeatedly violating a no-contact order is serious because it shows a willingness to ignore the court itself. Then something unexpected happened. Instead of demanding jail time, the protected person told the judge that she believed the defendant's biggest problem wasn't anger, it was his mental health. She said she wasn't convinced that jail would solve anything and encouraged him to complete the impulse control class that had been. Can someone deserve a second chance, even after being accused of threatening to kill the mother of their own child? That was the difficult question facing the judge in this emotional courtroom hearing. The defendant was already on pretrial diversion, a program designed to help people avoid prison if they follow strict court rules. But prosecutors argued that he had thrown that opportunity away. According to the state, after separating from his former girlfriend, he repeatedly contacted her, despite protective orders being in place. The prosecution called the woman to testify by video, and although she appeared nervous, her testimony immediately changed the atmosphere inside the courtroom. She told the judge that after she sought protection from the court, the defendant continued contacting her. Then she described the moment that frightened her the most. According to her testimony, the defendant threatened to kill her if she didn't drop the criminal charges against him. As the hearing continued, the judge carefully questioned the witness about their relationship. She admitted they had lived together for about a year and shared a child. She also testified that the defendant had physically assaulted her in the past, and that many of the incidents happened when he was under the influence of drugs or alcohol. But then something unexpected happened. When the judge asked whether she was still afraid